You're listening to the AP Partnership Podcast. We pack every episode with practical employment guidance and delve into the intricacies of the ever-evolving world of employment law. Follow us on Spotify or wherever you listen to your podcasts to catch the latest advice. Just like our employment service, our goal is simple: to empower you with knowledge that will protect your employer rights and help you make informed decisions. I'm your host, Holly, and today we're going to be talking about disciplinaries. If you haven't heard part 1 of Disciplinaries, then go back and have a listen to that, maybe before or after this episode, because it'll really help give you a little bit more context. Today I have a very special guest who will be answering a few questions about the disciplinary investigation and hearings process. Today I'm talking with Karen, who is an expert in HR and employment law. Karen, can you outline the key steps that are involved in a disciplinary investigation process?
Okay, well, the purpose of the investigation is to gather all the evidence that you might want to use in the disciplinary hearing. So you need to gather whatever it is that you're investigating, and then you need to review that, make sure it's clear and accurate and appropriate. You might need to get witness statements, so you would meet with the witnesses and either get them to write a statement for you, or you could interview them and write it down, but make sure you've got a recording of the witnesses and what the witnesses have to say. And that's pretty much it.
So, as we know, with the police and stuff, there's admissible evidence and then inadmissible evidence. Is it the same situation when it comes to employment law?
No, it isn't. We're not the police. We're just, HR people or managers or whoever it is that's carrying out the investigation. You're expected to be reasonable, thorough and reasonable. So you're expected to carry out a reasonable investigation, but you're not expected to have proof of things. You only need to have a reasonable belief of whatever it is that you're investigating. So you can pretty much use anything that is available to you.
That's really, really good. So basically you can use recordings or messages or whatever that you can get your hands on, really.
You can, yeah. Facebook messages, texts that have been sent to you, whether they're in or outside of working hours. Pretty much anything you can get your hands on, you can use, yes.
And you mentioned it has to be reasonable as long as, it's reasonable. What does that actually mean in practice?
Well, that's where employment law is what it is. Everything that you do pretty much in employment law needs to be reasonable. And in a disciplinary, your ultimate sanction that you apply also has to be reasonable, and it has to be based on a reasonable belief. So the police would have to have proof. You just need to have a reasonable belief. And yeah, reasonable means different things to different people, but you'd be surprised how often people come to the same conclusion as whether it's reasonable. So when you apply your sanction, you should be able to reason it out how you came to that conclusion.
I see. So I guess in that case then, it's so important for employers when they're going through this process to outline how they've taken these steps and how they've got this evidence in order to show that it's been in a reasonable way. Is that right?
You don't need to show how you've got the information, but you need to gather whatever would be reasonable. Information, it's quite obvious, depending on what the issue is. It's quite obvious, or it should be obvious to you. What do I need to show, like why we've got these allegations? It's quite obvious at the time. It can be all sorts of things that you might need to gather, depending on what it is that you're investigating or what you're going to discipline somebody for. So, yeah, it's difficult to say exactly what, but it's obvious at the time that you're doing it what would be considered reasonable. So, for example, you would be expected to, if there's somebody external, say somebody external to the organisation has called in and made a complaint, and that's what you're investigating, you would have to go back, you would be expected to go externally back to that person and ask them for a statement. And it might be that they refuse to give you a statement, because if it's the general public, or sometimes it's your customers and you don't particularly want to go and talk to them about it, you would be expected to. But if they then refuse, that would be good enough, because that's reasonable. You've asked them, they've refused, and that's as much as you can do. And that would be
I see.
considered reasonable, yeah.
Got you. So would you need to, as an employer, note that down that you try to contact this person, or would you just kind of just
Yes,
ignore
I would
that?
probably make a file note on anything like that. If you just want to document it, make a file note that you rang, they said no, and then yes, you can use that. That could be part of your investigation, part of the information that you would give over to the employee. Yes.
And what type of evidence could you get? What have you got any examples? Let's say it's a bullying situation. What evidence would you try and gather, or could you say would be available to people?
With bullying in particular, that's quite a difficult one, because quite often it's your word against their word. So you would normally get witness statements. So what you would do is the two parties that are allegedly involved in the bullying, you'd get a statement from each of those people, and then you would get a witness statement. And quite often when I talk about being reasonable, and you have to reason it out, if you've got one person saying one thing and there's two witness statements that are agreeing with them, then logically and reasonably you would have to reasonably conclude that that is the version, that is what happened. If there are no witnesses and it's one person's word against the other, unless you have some very good reason for being able to prefer somebody's evidence, which you are allowed to do, but you would have to be reasonable about it. So you'd have to be able to reason it out. I preferred their evidence because of whatever it might be.
I guess it's very subjective, isn't it, to the case, the situation.
It is, yes, it is. As I say, it's about reasonable belief. It's not about proof. You don't have to prove it, because, as I say, we're not the police. It's an internal investigation, and you're expected to do the best you can. But you are, so you're expected though to be able to reason it out. So when you look at it, most other people that look at it would come to the same conclusion as you. That's what's reasonable. That makes it reasonable.
I see. And what would you do in a situation where an employee doesn't want to be involved in the disciplinary process? What would you do if they're refusing to participate at all?
Well, that's not in their best interest, in actual fact, but you do get that scenario. So if they won't be involved in the actual investigation, normally you would want to interview the person that their allegations are against in an investigation. But if you can't, or if they won't, it's not fatal to what you're doing. You would just gather the other evidence as best you can, and you would carry on to a hearing. If you invite somebody to a hearing and they don't turn up, for example, then you rearrange that hearing to another date, and you warn them in writing that if they don't turn up for the second hearing, that you will go ahead in their absence. And if they don't turn up for the second hearing, then you would hear it in their absence, and then you would write to them with a decision. So you're using your information to make a decision without the benefit of what the employee has to say, which is why it's not in their best interest. Sometimes they don't want to attend because they don't want to turn up at your offices, or there can be all sorts of reasons why they might not want to. So you would normally offer them alternative ways of hearing it. So you can offer things like, we'll allow you to be accompanied by a family member, we'll hear it in an external place. You might even say, we'll come to your house and hear it at your house, if that was an issue, or we can do it in writing. Sometimes you can say to them, you can substitute somebody else to come and put your case for you. That's quite unusual, but you can do that. So you offer them those alternatives as well. But ultimately, if they won't take part, you go ahead in their absence.
And is that a common situation?
It can be quite common. People, for all sorts of reasons, it's not a pleasant experience, is it? It's not what you want to be doing. So yes, it's relatively common that people will not turn up. But normally, once you start to don't rush it. If you give them some time and offer them alternative ways of doing it, you could even do it on the telephone, I suppose, so that they don't have to see you. So there's alternative ways of doing it, and if you offer those, and then if not, you just go ahead anyway and say, right, I'm going to rearrange it for this date, and if you don't turn up this time, I'll hear it in your absence.
I see. And what is the process of a hearing? Where do you start? How do you set it up? What is the legal process?
Well, after you carry out an investigation, and then you look at all the evidence you've got from your investigation, and you make a decision as to whether you need to take disciplinary action. So the purpose of the investigation is to decide whether you have enough evidence and whether you think it's appropriate to move to a disciplinary hearing. If the answer to that is yes, then you write to the employee and you make them aware of what the allegations are. You do it in writing, when the hearing is going to be. You give them the right to be accompanied, and you give them any of the evidence that you're going to rely on. So again, anything that you've got, you make sure that they have prior to the hearing. You would normally allow probably 48 hours is a rule of thumb, a good rule of thumb, to give that person time to look at what the allegations are. So they need to be very clear what the allegations are, and look at the evidence and everything so that they can prepare to respond to you when they come into the disciplinary hearing.
So when it comes to the hearing, who's involved? Who would need to attend that hearing, apart from obviously the employee, but as you've just mentioned, they don't always do attend.
No. Okay, so the employee, you would expect them to be there, and they have the right to be accompanied by a fellow employee or trade union representative. They don't have the right to be accompanied by anybody else, but you can allow them to bring somebody else if they would want to. So if you have somebody who has, say, suffering from depression or a mental health issue, or they need help explaining things, you might, but you don't have to, you might allow them to bring, as I say, a family member to support them. They might be more comfortable with that. So as I say, you don't legally have to do that, but you can allow that, and normally I would allow that if they wanted to bring somebody else. You don't normally let them bring anybody legal, so a solicitor or anything like that. But again, you can, if you want to, allow that. But they have the legal right to bring a fellow employee or a trade union representative. And then you have the chairman, if you like, the person who's hearing the case and who is going to make the decision in the meeting, and normally somebody to take notes. If you want to bring a witness, this is on either side, either party, you're allowed to bring witnesses to attend the meeting, give their witness statement, if you like, and then leave. But again, it's rare that happens, very rare.
And what's the actual purpose of the hearing? Is it to look at all the evidence that you've collected in the investigation process, or what's the the purpose?
The purpose of the disciplinary hearing is for the employee to put forward an explanation or a defence to the allegations. So it's for them to tell you why whatever it is you're accusing them of either didn't happen, or why it was perfectly sensible and reasonable for them to have done what they've done. So it's their opportunity to put forward their defence against your allegations. And if they don't have a defence, they might admit it. They can put forward any mitigation. So they might say things like, well, I did do that, and I'm really sorry, and please will you take into account the fact that I've worked for you for 20 years and I've never made a mistake before. I don't want to lose my job, please treat me kindly. That's what the meeting is. The purpose is so that they can put forward their case and any mitigation. It's your job to listen to their side of the story.
And then what happens after the hearing?
Okay, then after the hearing, you're going to make a decision. So you never make a decision in the meeting itself. You finish the meeting, and then whoever the chairman is will look at all of the evidence again and take into account what the employee has said and any mitigation that they've put forward. They would look at all of that in the round and then make a decision as to, one, whether a sanction should apply, but secondly, what level that sanction should be. So again, it's about being reasonable. What would a reasonable employer do? What would they conclude? And that's the level of sanction that you would apply.
So then I guess after the hearing, you give that outcome, and then you just kind of go along in your day-to-day life again and just carry on as normal. Is that right?
Sort of. So what you do is you then need to communicate whatever decision and sanction you've made to the employee, and you can do that in several ways. You can either call them back into another meeting and tell them verbally what your conclusion is and how you've come to that conclusion, or you can write to them and tell them what that conclusion you've come to and what the conclusion is. You can sometimes ring them if they're at home. They might want to know quite quickly, so you can ring them and tell them what it is, what the conclusion is, and how you've come to that conclusion. But then you always write it down, write it to them, and give them it in writing, either post it to them or whatever, so that they've also got the answer in writing.
And then I guess they can use that and potentially appeal the decision, or they can just not.
Yeah, absolutely that. They get the right to appeal, and that's normally in the letter that you send them. So you have the right to appeal against my decision, and if you're going to do that, please write to me within X number of days. And then if they appeal it, then yes, you need somebody higher up than yourself, so somebody senior to the person that made the decision, to hear an appeal. And the reason they need to be senior to you is so that they can overturn your decision should they need to. So it's the thought process. If it was somebody subordinate to you, then they wouldn't be able to overturn your decision. That's why it's always somebody senior to yourself that makes that decision. And you pretty much go through the process again. Then the person that hears the appeal decides whether that sanction was appropriate, and if it wasn't, then they can give a different decision on appeal.
And do you find that many people do actually appeal the decision? Is it quite a common thing?
Again, it's relatively common for somebody to ask for an appeal. You know, quite often people are not always, nobody's happy about being disciplined, are they? But sometimes, yes, if they feel aggrieved, they will have somebody else rehear it, which is fair and reasonable.
Thanks for listening to our latest episode of the AP Partnership podcast. At the AP Partnership, our consultants' vast range of experience and skills mean you can call in on our HR, employment law and health and safety expertise as and when you need it at a budgeted cost. You have access to our decades of combined expertise to allow you to get the most from your biggest overhead, your employees. If you have any questions about what we've spoken about today or any other employment matter, don't hesitate to contact us for more information. Email us at info@appartnership.co.uk.